for the list.
From the main list, number 1 and 2.
Yes.
We have filed our notes of arguments in the matter as instructed by Your Lordship. We had in fact filed it yesterday.
Yes.
I'm sorry, my lord, I could not come personally. All the flights were cancelled yesterday.
Today?
Yesterday, my lord, the Indigo.
Yes, Mr. Jonathan Mitra was here yesterday. He also said his flight was, one of his flights was cancelled.
Yes.
Yes.
My lord, we have filed the detailed notes of arguments. My lord, I don't know whether my assistants have also filed the notes.
Yeah,
What
we have
do is
also
exchange the notes and
we
my
have
lord, come
also
back.
Today they are only filed. Today, yeah.
these ones.
Oh, so Mr. Shah, yes, what are your points?
Well, my points are, my lord, if Your Lordship sees, well, essentially that, my lord, so far as this is concerned, this is an LLP. Now, my lord, LLP requires, my lord, incorporation. And, my lord, we have incorporated, that's reflected from master data, which is a part of, my lord, my papers in the Order 41 Rule
No,
27.
the agreement was with Shurokkha Specialty. I think that the document was signed. A document was signed by Shurokkha Specialty LLP, but as a constituted attorney of.
No, my lord, may I, my lord, put it in a different perspective. My lord, there is, my lord, first of all, my lord, an agreement between the two, my lord, constituents of the LLP, that is at page 1 of the paper book. The two constituents of the LLP are, my lord, Suraksha Specialty and, my lord, Suraksha and Salvia Global. These are the two, my lord, partners.
Yes.
Now, my lord, if you lordship will kindly have a look at, my lord, that document, my lord, this is the LLP agreement. My lord, please see, my lord, these are the two constituents. Page 1 of the paper book, Suraksha Specialty LLP and Salvia Global LLP. Now, my lord, they agreed, my lord, to constitute, my lord, a different LLP in the form of a partnership, a limited liability partnership. And, my lord, they applied for the name. Now, my lord, so far as the master data is concerned, my lord, this is, my lord, the master data that was granted by, my lord, the Ministry of Corporate Affairs, that your lordship will find at page 66 of my application under Order 41 Rule 27. So, my lord, it was registered with the name.
Where is the
It was
application on 41? Where is that application?
My lord, there's an application, my lord. We have filed under Order 41 Rule 27, my
Where
lord.
is that application?
My lord, that's miss case number 4.
Case number 4.
Limited book on limited.
Now, please come to page 66 once.
Page
66. Well, this is the certificate of incorporation that was granted by the Ministry of Corporate Affairs. You will also see the name. LLP name is Suraksha Salvia LLP. Now, my lord, in this context, my lord, the provisions of the LLP Act become relevant.
yes.
Well, if your lordship has the LLP Act, well, your lordship will find, my lord, from section 3. Well, it's section 3 requires a limited liability partnership to be a body corporate.
Yes.
Section 5 says that, my lord, the partners of a limited liability partnership may be, my lord, both a body corporate or individuals. And, my lord, section 11, if your lordship will see, also, my lord, requires there to be an incorporation document. Well, the incorporation of document is the certificate of incorporation which I have showed your lordship.
Yes.
Now, so far as this is concerned, chapter 4 of the LLP rules, well, the limited liability partnership rules of, my lord, 2009 also provides, my lord, for the method and manner of incorporation of limited liability partnerships. Well, your lordship need not really look into that. That is the procedural part of it, which says, my lord, how the incorporation must take place.
No, admittedly, the contract was not with the LLP.
No, that is exactly what I am trying to, my lord, answer.
So the contract was with an entity
Well,
called Suraksha Salvia Global LLP.
Now, my lord, so far as this is concerned, this is what we call was a misdescription. Now, my lord, what in law, my lord, then is the existence of
No,
Suraksha Salvia.
if it is a misdescription, you should have corrected it. First, you
My lord,
correct.
so far as misdescription is concerned, your lordships have held that, my lord, that does not vitiate the document.
No,
And my lord, my learned friends have never sought to avoid the agreement. It is not their case that, my lord, this misdescription has vitiated the document. But if it was a matter of mutual mistake, well, then section 20, my lord, could have been resorted to say the document is void. But that was never their case. Now, my lord, today it is not my lord, learned friend's case that, my lord, there is an agreement with a non-existent entity.
You see that even those who signed the document was designated partner of Salvia Global LLP.
The correct name is
Well, Salvia Global LLP is correct. Well, Salvia Global LLP is one of the partners.
Yes.
Well, Suraksha Salvia Global LLP does not exist. The name of the LLP with which the agreement was entered into is Suraksha Salvia LLP. Salvia Global LLP is one of the
Suraksha Salvia Global LLP, the signature stamp is of Salvia Global LLP, designated partner.
Yes.
Right. No difficulty there.
So
because that is one of the constituent partners of the LLP.
So on behalf of Salvia Global LLP, the person who signed, he designated himself as one of the partners of Salvia Global LLP.
Yes.
Now,
well, and you'll also find Salvia Global LLP is one of the partners in the document at page 1 of the paperbook.
no, you mean to say there is no existence of Suraksha Salvia Global Limited LLP?
No, because the incorporation certificate recognizes the creation of a juristic entity which is Suraksha Salvia LLP. And as a result, the partners cannot sue in their individual names. Unlike in a partnership, under the Partnership
No,
Act,
there is no existence of Suraksha Salvia Global Limited.
Global LLP.
Suraksha Salvia Global LLP. No, there is
That's right.
of
No.
Suraksha Salvia Global LLP. Very well.
My lord, that is what we say is a mistake. It's an inadvertent mistake. And my lord, here the next thing is, my lord, please see, my lord, in recognition of, my lord, the fact that the agreement was entered into with Suraksha Salvia LLP, my lord, what has happened? My lord, please have a look at, my lord, some of the documents which are on record. Please have a look at the paper book at page 95. My lord, here you'll also will find that the government of Meghalaya is writing to Suraksha Salvia LLP. And my lord, granting it registration under the Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Selection Act.
You see that this document of Surakha Salvia Global LLP
Yes,
is signed by one Salvia Global LLP.
yes.
So either Salvia Global LLP is the signatory or is binding, but how Surakha Salvia LLP becomes a party to the contract?
Salvia Global LLP is one of the partners of my lord, document which constitutes the limited liability partnership.
No, the agreement is between Surakha Specialty LLP and
That's
Salvia
right.
Global LLP.
Now, my
There
lord,
is no
Salvia Global,
existence. There is no existence of any entity called Salvia Global Surakha Salvia LLP.
no, my
There
lord,
is no
what have they
existence.
done?
Even if you go for the customer's name, I would have followed Surakha Salvia LLP has come and said that instead of Surakha Salvia Global LLP, it should be Surakha Salvia LLP.
Well, lord,
But
that is, my lord, not
fine,
the case of the parties. My lord, they have all recognized the fact that, my lord, these two entities have.
recognition will not do. Recognition will not do, Mr. Shah.
My lord, we'll also see page 4 of the paper book, wherein both the parties agree to constitute the LLP as Suraksha Salvia LLP. The first paragraph at page 4 also. The two constituents agree that the name of the LLP which they will constitute or incorporate will be named as Suraksha Salvia LLP. My lords, at page 4 of the paper book.
No, a limited liability partnership will be between Surakha Specialty LLP and Salvia Global LLP.
My lords.
Right,
And
right,
they will carry on the business in the name of Surakha Salvia LLP.
Yes.
right.
But the agreement which is entered into does not refer to Surakha Salvia LLP.
My lords.
It is possible that this was a business of Salvia Global LLP wants to carry on, have a different contract with
That
them.
is, my lord, that
It's
is not the
possible.
pleaded case.
No,
No, no,
it's
well, that is not
it's
the
not the
pleaded
thing.
case.
It's
Well,
not
that is not the pleaded case at all.
I have
My
not
lords will
for
see
the
page
limited.
33
See,
also.
does it say in the agreement that they are forming this LLP for the purpose of executing this contract? Does it say so in the agreement? I would
Well,
have
it's so
followed.
far as this is concerned, well,
They made the form. They formed this company for the purpose of. Sometimes it so happens that two of the entities come jointly and say this entity is formed like a joint venture agreement. We merge together and this is a new entity created for the purpose of executing this contract. But when Salvia Global LLP is concerned, then let Salvia Global LLP what is the bar in a Salvia Global LLP in filing it, that is what you said, that I'll take instruction
I,
to come back.
no, well, so far
And
that is
what
concerned.
that is why the matter was urgent last time.
Yes, Salvia Global LLP is not the entity which my learned friends recognize.
I
They
recognize, my
recognize
lordship.
Suraksha Salvia Global LLP.
Page 32, your lordship. Only 2 pages, your lordship, kindly see.
Just me.
No, let me finish. I would like to show some law on the subject also. Please, see. Here, what is my learned friend's case? They say that we have entered into an agreement with Suraksha Salvia Global LLP. That is where they stop. Now, Suraksha Salvia Global LLP is not in existence. It is not their case that they have entered into an agreement with Salvia Global LLP. Not their case. Their case is I have entered into an agreement with Suraksha Salvia Global LLP, and that is where they stop. Now, they have granted permissions to Suraksha Salvia LLP. They have accepted invoices raised by Suraksha Salvia LLP. They have made payment to Suraksha Salvia LLP, not to Suraksha Salvia Global LLP. And the correspondence, including the show cause notice, was issued to Suraksha Salvia LLP. The agreement says it is non-determinable in nature. In spite of the agreement being of non-determinable nature, and says that even in the event of a default in the performance of obligations, first 45 days cure period notice, and then 90 days notice before termination. None of that followed. Proceeded to terminate. The law is very clear on the subject that when an agreement is not determinable in nature.
But we are unable to understand why Salvia Global LLP has not filed a section 9. The matter would have been.
Cannot, my lord, because the individual constituent partners of a LLP.
Let their objection be taken by them, then we shall see to it. When an entity is in existence, and he has we are wondering why, in spite of existence of an entity who has signed this agreement, that entity is reluctant to file an application under
that entity is not, my lord, the entity with whom the agreement has been entered into. Then, my lord, I shall be surrendering my position altogether. My lord, your lordship, my lord, will not, my lord, ask me to do that. Because, my lord, in that case, my lord, Suraksha's speciality goes out of the picture altogether. Lock, stock and barrel. How can that happen? Their position is manifested by their conduct, and the conduct becomes very important. Why have they accepted invoices from Suraksha Salvia LLP and made payment to Suraksha Salvia LLP? Why have they issued the show cause notice to Suraksha Salvia LLP? And the law, it's not as if misdescription does not happen. Law makes a provision for that. May I request my learned friend to hand up to your lordship 2003-8 STC 613. There is often a mistake in a schedule to a document. Does that vitiate the document?
Yes, which judgment you are referring to?
Please have a look at 2003, Volume 8, Supreme Court Cases 613. This recognizes the doctrine of falsa demonstratio. Please, have a look at paragraph 13.
2003, Volume 8, STC?
Page 613. May I just place paragraph 13 for your lordships?
No, we don't have the book, so.
I understand my learned friends had given.
You say there is no existence of Suraksha Salvia Global LLP, correct?
Yes, my lord.
Correct?
Yes, man.
Come to page 113. Minutes of the meeting. The person
Minutes of-
17.
Hello, Your
Surakha
Lordship.
Salvia. Yes, page 113. Sri Christopher Running, Surakha Salvia Global LLP, Upper Lightung, Shillong. And this corresponds to, if you come to page 38 of the agreement,
Page 38 of the MOU, my lord.
MOU. Exactly, that is the description. Private partner.
Yes, one of the partners is that.
He is very much there, so you can't say this. There is no existence of this, and he is
Well,
part of the member present in the technical expert committee meeting. So if he is not there, suddenly he was how he was by planchette he appears.
Well, can you have a look at
Page
may I show you-
161. Page 161. Notice
So
also.
these
Their
are-
notice
just,
also.
just a minute. So your
Well,
submission that there is no existence of this misdescription, it falls flat, Mr. Shah.
Well, your lordship is looking at the MOU first. Well, let us
No, no,
look
we
at
come to letter. You said your submission was there is no existence. That does not
Well,
appear to be the correct facts of affair.
well, may I say
No,
this?
technical expert meeting, he was there. They were deciding on this. There may be very internal arrangements. We go by the document.
Well, your
Because
lordship
of this false demonstration will not apply to this case.
your lordship will kindly
Yeah.
consider one thing.
Page 161. Their legal notice also to us, Milo. Page 161.
Well, your lordship will kindly see the
Last time
number of
we had
documents.
done this, you say that you will try to have you will
Well,
file the
please consider one thing. Well, today, my lord, your lordship will then allow Suraksha Specialty LLP to file a petition.
We are not concerned with this. Who is the
Well,
party?
that's it. Today, when an LLP has been constituted, and my learned friends have entered into an agreement with Suraksha Salvia Global LLP, the question is that LLP has to be an incorporated entity. That is the requirement of the LLP
we
Act.
don't know any, we don't we were only you gave it an impression that there is no existence of Surakha
Well, it cannot be unless it is
No,
registered.
Surakha Salvia Global LLP has no existence.
Well, no existence in law.
If that be so, how this page 130 that representative was there and he participated and everything was there. And then again, the notice our client, the notice at page 161 was Surakha Specialty LLP and Salvia Global LLP.
Yes, well, because these are the two entities. These are the two partners.
They are the only signatories, Milo.
Just a minute.
Of course, my lord. Of course, my lord. Who else will be a signatory? These are the two constituent partners of the LLP. Who else will be the signatories?
Very well.
Now, my lord, the question is, my
And
lord,
the
here,
show cause notice was issued to Surakha Salvia LLP.
that's right.
That is what you mean to say at page 166.
Yes, my lord. My lord, please see the show cause notice one. My lord, the show cause notice, my lord, please see it's issued to Suraksha Salvia LLP Medical Diagnostic Laboratories. Then, my lord, next paragraph, please see how, my lord, the names have been interchangeably used. Second paragraph. Whereas for the realization of objects, my lord, Suraksha Salvia Global LLP. And then again, my lord, the next paragraph, Suraksha Salvia LLP. So, my lord, the names have been used interchangeably.
No, but your argument that there was no existence of Surakha something that is wrong.
No, my lord, may I only say this? My lord, as per the LLP Act, my lord, an LLP has to be an incorporated entity. My lord, if my learned friend can show, my lord, that, my lord, Suraksha Salvia Global LLP has been an incorporated entity, then, my lord, your lordship will, my lord, ultimately say that my submission is wrong. My lord, without incorporation, an LLP cannot come into existence. Because it is a limited...
Then if this contract is not enforceable, you cannot have it done by an indirect way.
Well,
if
it is...
contract is not enforceable by an unregistered firm, let us put it, if it is coming under section 69 of the Partnership Act.
No, it's not governed by section 69.
I'm just giving an example. Then this contract will not be enforceable in law.
My lord, my learned friends...
That you cannot circumvent by saying...
No, my lord, with the greatest of respect, my lord, that cannot be the position when by conductive accepted performance. through an entity, my lord, which is a case of misdescription.
We may file a suit, but not by arbitration. We cannot go into this question by arbitration. You file a suit.
Well, of course, your lordships can. After, my lord, the OPG Global and after, my lord, Cox and Kings, your lordships can. Well, because the group of doctrine, my lord, entities has now come into existence. Your lordships have given it judicial recognition. I shall cite those judgments.
Those are held to be subsidiary companies inextricably connected.
My lord, the question is, my lord, here. No, my lord, here, my lord, the question is, my lord, whether, my lord, the government has recognized performance to them. The government has made payment.
Suppose A and B enter into a contract having an arbitration clause. Both of them agree that the contract may be performed by C. Does C becomes a party to for the purpose of arbitration, not for the purpose of anything else?
Yes,
not for the purpose of anything else.
No, my lord, of
now,
course,
arbitration is a special contract, is not a general contract.
My lord, please, my lord, see, my lord, the judgment now. My lord, please see OPG, my lord, once.
No, we'll come to the judgment later. Let us have the fundamentals clear on this. A and B agreed that C will perform the contract, and invoice are issued in favor of C. Payments are made to C. And this agreement contains an arbitration clause in between. Now C says that B is not making payment to me. A is not making payment to me. Then the dispute arose. A and C will have an agreement binding to the limited extent, and that C may file a suit based on the representation. But there is no arbitration clause, so that contract can't be enforced by arbitration.
My lord, with the greatest
C may have a general law. Remedy.
My lord, perhaps, my lord, that, my lord, spectrum has now been expanded. My lord, perhaps, my lord, now, my lord, the spectrum has been expanded to include, my lord, other entities who are involved in the performance of the contract, and therefore, my lord, can ultimately be bound by an arbitral award also. But may I, my lord, make this very humble request, my lord, to your lordships. Well, I have, my lord, given, my lord, my notes of arguments. I have, my lord, given reference to judgments, including, my lord, specific paragraphs which may be of relevance. My lord, may I request your lordships to kindly, my lord, have a look at this judgment. I shall also look at my learned friend's note. My lord, we can come back tomorrow also.
Where's your notes?
Lordship, only two submissions, my lord. Only 2 minutes, my lord. Lordship, kindly see all these factual issues will be clarified looking at 2 documents only, my lord. MOU, your lordship has seen at page 2032. Kindly see MOU, page 32.
Yes.
The agreement on 21st June 2019. Your lordship may kindly mark the date 21st June 2019. Now, this agreement, my lord, will lordship, the handwritten part is Suraksha Salvia Global LLP, my lord. Your lordship has Suraksha, and the bottom, if your lordship will see, the seal is Salvia Global LLP and designated partner. By hand, my lord, and the second person, my lord, in the agreement, as if this, your lordship will kindly see page 33. 33 is clause 1, parties to memorandum of understanding, MOU, my lord. With reference to the above, Government of Meghalaya through Department of Health and Family Welfare has agreed to sign and execute a memorandum of understanding with Suraksha Specialty LLP in association with Salvia Global LLP, my lord. So these are the 2 entities which are there by handwritten, my lord. Suraksha has been added inadvertently, but so there are 2 entities before your lordship. The parties to agreement, your lordship is rightly said, and in terms of section 7, only parties to agreement are Suraksha Specialty LLP and Salvia Global LLP, my lord. This clause, and then this is the date 21st June. My lord, kindly see MOU's date. MOU which they have formed. MOU's date is after 2 months of this agreement, my lord. Kindly see the date. 21st August 2019.
Yes.
At page 1. Page 1 of the volume, my lord. Page 1 of the volume is...
This incorporation is after this agreement.
After 2 months. After 2 months. And they are not party to the agreement, my lord. That's a basic...
This is incorporated in July 2019.
Incorporated in July, my lord. So this very LLP born. There is a question of going into all other issues, my lord. And section 7 of arbitration agreement is very clear. We have not entered into any arbitration agreement with this entity. And moreover, my lord, this MOU is basically amalgamation of these two juristic entities. Under LLP Act, my lord, under section 60 to 62, amalgamation has to be approved by NCLT, like Companies Act, my lord. There is no, this entity is also not there in law for us. And this is what the finding of the trial court is, my lord. If your lordship will see one page of 309 of the trial court order. And my argument was, my lord, what my learned senior counsel was saying is completely incorrect. My argument was that there is page 309. In the instant case on 21st August 2019, Suraksha Specialty LLP and Salvia Global LLP formed a limited liability partnership by the name and style of Suraksha Salvia LLP. However, there is nothing to show that said firm has been registered as per Limited Liability Partnership 2008. Thus, newly incorporated firm could not have right to sue or be sued in the name of Suraksha Salvia. No right has accrued to the petitioner in respect of any contract entered by Suraksha Specialty and Salvia Global LLP in the absence of registration. In view of thereof, this application file is not maintainable since the petitioner is not a party to the MOU.
What is it?
And I am not going into the merits, my lord. It's a infrastructure project. It's a terminable contract. It is a statutory bar, my lord. And notices, your lordship, I have shown the notices, my lord. Kindly see page 161 and the correction also. There is an email.
Page?
Page 161, my lord, is the notice. Because they know who are the parties to the MOU, my lord. They are saying that this whole chimera is being created that, dear sir, our clients Suraksha Specialty LLP and Salvia Global LLP. And this is, and on correction also 163, my lord, the
Yes. Mr. Shah is possibly not getting the connection.
So, there is, on the day when I entered into agreement with Salvia Global LLP and Suraksha Specialty LLP, this entity was not even born, my lord, and therefore there is no question of having any arbitration agreement. Parties to the agreement as per the MOU, my lord, at page 33, your lordship has noted is a Suraksha Specialty LLP and Salvia Global LLP. None of the parties have invoked section 9 application, my lord. And this entity, Suraksha Salvia LLP,
And
got
even
registration in
and
July.
Even the legal notice with the corrections make it clear.
Yes, my lord.
We are writing this letter under the instruction
Yes, my lord.
on Suraksha Specialty Limited and Salvia Global.
Global LLP, my lord. Now they are trying to create a kind of story that no, this agreement is with the newly created entity with whom they had some amalgamation which was not even inchoate, did not born also, my lord. So section 9 by the
But how you write on 9th October address to
9th,
Salvi-
Milord, because there were
Shulokka Salvi LLP?
Milord, because what has happened, one typographical error in the MOU at one place, and the officers, Milord,
Shulokka Salvi LLP.
yes, Milord,
Now,
your lordship
Shulokka
will,
Salvi LLP is the applicant before us.
yes, Suraksha Salvia LLP is the applicant, Milord, and two entities which signed the agreement, Milord, they are Salvia Global LLP and Suraksha Specialty LLP. And my argument before the trial court, my lord, is completely different. Kindly see my arguments at 287.
But this notice of this document on page 166 is damaging.
Milord,
That's damaging.
Milord, to that extent, my answer is, Milord, the Lordship has already said that at best, if they say that there is some sort of, but they are not party to the arbitration agreement, Milord. They can go file a suit, Milord.
But you refer to the clause in MOU to terminate, you say it's.
If your Lordship will 166 also, my so-called notice your Lordship is referring to.
Yes.
Now, your Lordship will see, kindly see what is the name description given, Milord. Page 166, top. Christopher Rani, Director, Suraksha Salvia LLP. And Christopher Rani is the signatory, Milord, designated partner. If your Lordship will kindly see the MOU of page 32, Milord, kindly come to page 32. And their signature also at page. If you page 38, Milord, page 38, clause 4, Milord, notice. Clause 12 at the top, notice, Milord. And private partner, Milord, if in the table in the page 38, Milord, is a private partner, designated partner. So 166, your Lordship has referred to, Milord, is a private partner, designated partner, who is, and everywhere, if your Lordship will see page 38 itself, in the bottom, it's a designated partner. Bottom also, your Lordship will find this agreement has been signed by designated partner. So notice has gone to designated partner, Milord, Christopher Rani. And his name is there, Milord, at page 32, Christopher Rani, Salvia Global LLP, through authorized signatory, Christopher Rani, Milord.
My lords will also see the last paragraph of page 166, the show cause notice, whereas Suraksha Salvia LLP has failed to meet the terms and conditions of the MOU. The last paragraph in 166, the show cause notice.
But notice has gone to, Milord, designated partner, Milord. And as per MOU, Milord. And on that day, there is no, the Suraksha Salvia LLP is not the signatory to the. Even it was not born on the day, 21st June 2019. And their MOU also cannot be invoked and relied upon, Milord. That is the MOU of 21st August 2019. And it talks about amalgamation. If your Lordship will see, page 1. Suraksha Specialty LLP and Salvia Global LLP.
Yes.
And page 4, Milord. So page 4 also, my lord, in terms of section 60, 62, my lord, they are not in existence also of LLP.
Yes.
So my case is, my lord, that there is no MOU with the entity. They are not signatory to the agreement, and therefore the finding of the learned trial court is correct on law and fact both, my lord. And this entity has not even been amalgamated in terms of section 60 and 62 of Limited Liability Partnership Act, my lord. And both entities which are signatory to the agreement, my lord, they are not before your lordship. And 289, 287, my lord, my argument to the effect has been noted by the 287, my lord. Kindly see to page 287 of the paper book.
Yes.
In fact, their own case in the section 9 petition, my lord, at page 289, paragraph 1.7, your lordship may kindly have a look. They are trying to make out completely new case before your lordship. Before trial court, they say it was inadvertently mentioned. Your lordship will see 289, and I have referred to the relevant paragraph of their petition also. Page 1.7, 289, paragraph 1.7. Petitioner in para 9 of the petition has stated due to inadvertent, petitioner has been mentioned as Suraksha Salvia Global LLP instead of Suraksha Salvia LLP.
1 point, paragraph 1 point.
Paragraph 1.7 at page 289.
So inadvertent mistake, they say.
And they said inadvertent mistake.
And what is the stand now according
And
to
now
you?
stand is that this is the entity which has been created not subsequently. This has been created and it has been executing the project on behalf of these two entities, my lord. And therefore there is an arbitration agreement with the new entity.
Very good. Very good.
So therefore, my lord, this appeal in my humble submission must fail on this ground alone. On merit also I have something to say, but that issue is not before your lordship, and one of my wing is under their occupation and we are facing difficulty in because we have to expand the...
Well, anyone, we make it CAB then? CAB then?
Only one thing, if your lordship will kindly see, I'm sorry, there was some problem with the internet. I was logged out. Just kindly come back to the MOU once. Yes, MOU once, just one paragraph I want to show.
Yes.
Now, here, as your lordship has seen, this is the internal, this is the second page of the MOU. Should be page 33. Parties to the memorandum of understanding.
Yes.
Kindly allows me to place this. With reference to the above, the government of Meghalaya through the Department of Health and Family Welfare has agreed to sign and execute a memorandum of understanding with Suraksha Specialty LLP in association with Salvia Global LLP. These are the two constituent partners. So, they have agreed to enter into an agreement with an LLP of which these two are the constituent partners. Now, the only LLP which is incorporated and registered well, on the basis of, my lord, an agreement between these two partners is the Suraksha Salvia LLP. I've shown your lordship the master data. Now, my lord, my learned friends acknowledge the fact that there is an entity which has been created in an agreement entered into between, my lord, these two parties mentioned in paragraph Roman 1 of the MOU. The question is, my lord, which then is this entity? Now, my lord, the entity which is on record, my lord, in the, my lord, statutory portals is Suraksha Salvi LLP, and that is why, my lord, we say that it's a case of bona fide mistake. And, my lord, that is exactly what, my lord, paragraph 1 of the section and application has also stated. And that is why we say that it's a case of misdescription, because you have also correspondingly referred to us as Suraksha Specialty LLP, Suraksha Salvia Global LLP and Suraksha Salvia LLP. Now, my lord, my learned friends will then have to show that no, there is an entity in existence in law, because it has to be permanent by the mandate of statute be a registered and incorporated entity, which is there in the name of Suraksha Salvia Global LLP of these two are partners. And, my lord, that is why, my lord, I have relied on, my lord, documents which says that, my lord, in fact, my lord, I have also relied in my note on a judgment which says that you cannot possibly have an agreement with a non-existent entity. And accordingly, my lord, amendment was allowed. It says you can have an agreement with a natural person, you can have an agreement with an artificial person. But, my lord, the artificial person is not there. Because the artificial person, by my lord, my lord, mandate of law has to be an incorporated entity.
But then, Mr. Advocate General,
Yes, Lordship.
Mr. Shah has a point. If you
Yes.
come to page 3
Page 3.
of the agreement,
Yes, Lordship. If your Lordship will kindly come to page 3, my Lord.
of the agreement,
Yes, my Lord.
see the definition.
Yes, my Lord.
Designated partners
Is defined in section 7 of limited liability partnership. Partners are those.
Partners are those who are admitted
Yes, my Lord.
to Suraksha Salvi LLP.
And
So
then,
Suraksha Salvi LLP is the applicant here.
yes, my
With the
Lord.
mutual consent of the designated partners and into the designated partner,
Yes, my Lord.
then it is hereby agreed by and between the parties hereto as follows.
Yes, my Lord.
A limited liability partnership shall be carried on in the name and style of Suraksha Salvi Limited.
Correct, my Lord.
The LLP number is this.
Yes, my Lord.
The LLP as constituted under
Yes.
this deed
Yes, my
shall
Lord.
be deemed to have commenced on 26 July, that is the certificate of incorporation.
Yes, my Lord.
Suraksha Salvi shall have registered officer and such.
Yes, my
The
Lord.
first and second party partners and such and such. The first and second party shall be the designated partners on the incorporation of Suraksha Salvia.
Yes, my Lord.
Each designated partner, so the initial contribution,
Yes, my Lord.
the name of the partner is there.
Yes, my Lord.
So this,
My Lord, there is
so
an
this-
entity, they have, with these two entities, my Lord, who are signatories to the agreement with me, my Lord, they have tried to create one amalgamated entity, which is called Suraksha Salvia LLP, which is appellant before your Lordship.
No, so the thing is this, you are absolutely correct. When the agreement was entered into, there was no existence of this entity.
Yes, my Lord.
But after 26, practically that entity no more exists, because a limited liability partnership will be carried out in the name, and so there will be a constitution of Suraksha Salvi LLP
Yes, my Lord.
in which these two persons should be partners.
Yes, my Lord.
But in the agreement that they have with you,
Yes, my Lord.
this was not of course they cannot mention it.
Yes, my
So
Lord.
it remains as
Yes, my
as
Lord.
that.
And my Lord, if they have created this entity, this is an amalgamated entity, my Lord. And kindly see, amalgamated entity requires approval of National Company Law, NCLT, Section 6062.
No. With the greatest of respect, my lord, all that the Limited Liability Partnership Act requires is that, my lord, they should have a certificate of incorporation.
Because if there are three entities, my Lord, if your Lordship will kindly see,
No, difficulty is this, Mr. Shah. the communications made on your behalf, even in
Yes.
2024, suggest the existence of Shurokha Specialty LLP and Salvia Global LLP. You are not disputing that these two entities are not in existence.
Malad, kindly allow me to
They are
Malad,
in
show you
existence.
the communications. Malad, kindly allow me to show you Lordship the communications one by one.
No. Please tell us whether Shurokha Specialty LLP is existing or
Yes.
Salvia Global LLP is existing. So,
Salvia,
so a entity which was not born yet, that cannot enter into an agreement.
Malad, it's Malad something we know, call Malad regularly by Malad ratification, by conduct. Malad, kindly see what happens. You enter into an agreement, you
That's a
agree to
different.
constitute an LLP.
That's a question of fact.
No, Malad, here
So
Malad,
you file a suit if you want to have you file a suit, but not arbitration.
Your Lordship will kindly Malad have a look at the correspondence. Your Lordship has said, Malad, let's see the correspondence.
No, not only
How is
that,
the
you see the
government-
last correspondence, you see the notice by Sandersons and Morgans at page 161.
They are in
Then
existence.
the corrections.
They have
the
entered in.
corrections at page 164. And it is not that these partners is kind of a pre-incorporated contract, enforcement of a pre-incorporated contract.
Malad, the notice has gone, Malad, on behalf of Malad, the two partners.
No.
Page 161, Your Lordship.
You should have gone in the name. You should have gone in the name of the entity, which according to you is the entity, but under a misdescription.
Malad, here, Malad, what has been stated, if Your Lordship sees, Malad, this notice itself.
No. First, you see whom here they are representing. Very clear. Under instruction from it should be Shurokha Specialty LLP instead of Diagnostic and Salvia Global. So under their instruction, they're writing.
Yes, Malad, but they say that, Malad, they have
Whatever they
constituted.
say, we are on a section. We are on a enforcement of an arbitration agreement.
Malad, for that, Malad, will Your Lordship please have a look at, Malad, the Cox and Kings and Malad OPG once.
Sorry.
Malad, may I request Your Lordship to please have a look at, Malad, the Cox and Kings and the OPG judgment.
See, in all the judgments that you have seen, even the global, you will find those subsidiaries were in existence at the time when the agreement was entered into. None of the, Mrs. Shah, you've shown us a case that an entity was not even born, and the Supreme Court has said that entity becomes part of the arbitration agreement. You are through. You show me one case where an entity was not born, and the Supreme Court has said, very well, this entity may not have been born at that point of time, but he has, under Section 7, he comes as a party to the.
Malad, my answer is, Malad, very simple to Your Lordships. Malad, my learned friends
Is
have
it more simpler than the question or what?
No, Malad, I'll tell you, Lordship. My learned friends, Malad, have not, Malad, stated that the case was, Malad, their agreement was with partner A or partner B of, Malad, this LLP. Their case is that they have an agreement with, Malad, an LLP which is constituted of these two partners. That is, Malad, the paragraph of the, Malad, MOU that I showed to Your Lordships. Malad, let's go by the pleadings, the pleaded case. Now, Malad, the pleaded case is not, Malad, that the government of Meghalaya has a, Malad, agreement with Suraksha Specialty LLP or Salvia Global LLP. Their case is they have an agreement with an LLP which is made out of these two entities. Now, Malad, we are only trying to, Malad, discover what that entity is. Now, Malad, Your Lordship is right when Your Lordship says that, Malad, so today the agreement was entered into one day before, Malad, the certificate of incorporation came. Malad, because the expectation was perhaps that, Malad, they will get a sanction for the name Suraksha Salvia's Global LLP. The sanction came for Suraksha Specialty LLP, Suraksha Salvia LLP. Malad, does that ultimately mean that the agreement, Malad, ceases to exist? Or does that vitiate the agreement? When, Malad, the parties have proceeded on the premise that, Malad, there is an incorporated entity made out of these two parties, Malad, which is now the
Mr.
partner.
Shah, whatever you are saying is maybe very attractive had it been a suit. We are enforcing an arbitration agreement.
Malad, for that, I just request Your Lordship to please have a look at, Malad, once, Malad, the
Box
Malad,
and key. Box and key.
2024. Yes, Malad, OPG, Malad, first.
Give us.
Please have a look at the judgment in this is 2025 volume 2 Supreme Court cases. Paragraphs 91 to 93.
91.
Yes, paragraph 91 to 93. This ultimately relies on Cox and Kings. Cox and Kings is a very elaborate judgment.
91. See, as I said, Mr. Shah, a reference was made to arbitration. So one of the point was whether it could be, it was that binds the parties or not. So based on the aforesaid facts and the evidence brought on record during the arbitral proceedings, the tribunal concluded that the group of companies doctrine is applicable. OPG and R2 have represented themselves as a single economic entity, unlike the present one, which could switch duties and obligations. As I said, either of them would have come. What you are saying, you are through. R2 is a proper party. Both OPG and R2 are bound by the arbitration agreements, which gave rise to the arbitral proceedings. OPG and R2 were jointly and severally liable to be claimed complying with the above.
Then please, allow me to read paragraph 92 in Cox and Kings versus SAP India. A constitution bench of this court held that by interpreting the express language employed by the parties in the record of agreement, coupled with surrounding circumstances of its formation, performance, and discharge of the contract, a court or an arbitral tribunal is empowered to determine whether a non-signatory is a party to an arbitration agreement.
Non-signatory was born, Mrs. Shah, please. Here, the non-signatory was born at that point of time when this was done. Let us not read a judgment out of.
The non-signatory here is Suraksha Salvia LLP, and the
It's
non-signatory.
Not even born, Mr. Shah.
No, that's all right. But in performance, they've accepted performance with Suraksha Special Salvia LLP, and that is what the judgment says. Please see. Formation, performance, and discharge of contract. In discharge of contract, you have accepted payment. You have made payment to Suraksha Salve LLP. You have accepted invoices from Suraksha Salve LLP. You have granted permissions to Suraksha Salve LLP.
Very well. Yes, anything else, Mr. Shah?
No, I have stated everything I had to say in my notes.
Only Cox and King, my lord, one paragraph.
Yes. Yes, Mr. Shah.
Now, here, so far as this is concerned, so I say, they're relying on Cox and King that today, ultimately a non-signatory, which in this case, is Suraksha Salve LLP, becomes a party to the arbitration agreement by conduct, by performance.
Paragraph 230.4, my lord, of Cox and King.
Very well. We'll consider it.
Yes. 230.4, my lord.
It's clearly a case of misdescription. Now, the government is trying to avoid
the part.
Its obligation
it was
to remain
not
bound.
even born on that day.
Here,
it's just like your Alice in Wonderland, which makes us curiouser and curiouser for the other two entities not being coming.
What the government is trying to do is very obvious. They have entered into a contract, agreed that it will not be determinable, agreed that it can be specifically enforced. These are the express terms of the contract.
Why the other two entities are not filing? We are not getting any answer.
No, because
but because the impression that you gave us last time was that you will advise your client to take appropriate. In the meantime, you take.
Well, the difficulty will be, matlab, if either of them file, matlab, then the other party will be out.
Let
Then
them
matlab,
file,
it will
jointly
be
file it. Let them jointly file it. Who said? Who said? Let them jointly file it. Why the other party will
Matlab,
be out?
again, matlab, the answer in law is, matlab, when it is an LLP, matlab, it is, matlab, the constituent partners have no right. It is only the incorporated entity which has the right to sue or be sued.
No, no. The parties were to the signatory. Let them file the application. Let them file the application. Take down. What's the order? Hearing concluded. CAB. Thank you.
Grateful.
Great to know.
Understand these books. Huh?
On supplementary list.
Yes.
Number 1.
Yes. Okay, these books will go on.
Affidavit has been filed in this matter, my lord. But we have sought some more time to file it.
I'm not aware of this. Please just tell us.
Yes,
Mr.
ma'am.
Advocate General. Do you have a heritage committee here in
Yes,
the
ma'am.
state of Meghalaya?
Yes, we have a heritage committee.
Is it constituted under the municipal law? Or
It is
some
constituted
separate
under
act?
the Act, my lord. There is a Act under which it is constituted, my lord. And that Act, my lord,
Is
is
it under the municipal law? Or the
Meghalaya Heritage Act 2012, my lord.
Heritage Act?
Heritage
2012?
Act 12.
So you have a committee.
Yes, my lord. We can refer.
So have they considered this to be a heritage bill?
That is what we are trying to ascertain whether it has gone before the committee or not. That's why I said that status quo may be granted and matter be referred to committee to examine this aspect.
I think that is better. No? Let the committee report comes. Just give us.
Meghalaya Heritage Act.
think senior counsel is not available, Your Lordship.
No problem.
We are just directing a committee.
Meghalaya Heritage Act.
Just give us the act, where's the act?
Fine.
The file. Oh, yes.
It's fine.
Stay down. There is one, the amicus is not there.
Yes, Your Lordship.
Very good. You are Miss Slong.
Yes, Your Lordship.
Very good. The Lord Advocate General has paid for time.
Gonna remain this, number one.
US police matter. State of. Oh yes, the original record. Please produce.
Lordship, yes, I have brought it. May it please your Lordship.
Please produce. If he has made a correct declaration, if you have put it wrongly, then
Lordship, I. Lordship, kindly have the originals.
just give us.
Lord.
Correct age, correct date of birth.
Lordship, kindly have the.
No, please give the date. What is the correct date of?
26 August 1967, Your Lordship.
This form is filled out. Signature. This whose signature is her signature. Document, but they have sent it for verification. Which he ultimately signed.
No, there is nothing as for verification.
Agreement. 12 years. Date of joining. This one document. This was submitted. This was the letter, and was the letter. You got an correction of the date. When you retired,
She retired on 31st August 2024, Your Lordship.
August 24. Oh.
Lordship, according to her,
August. Oh. Yes, I submitted two. So you just show us these 3 birth certificates because it appears from this letter of 23rd October 2024. It may mention that the incumbent has submitted 2 school certificates. Now, when these 2 school certificates were submitted?
No, sorry.
Yes, madam.
If Lordship kindly have the memo of appeal at page 40.
40.
Lordship, yes. Before I come to that, if your Lordship kindly have page 18, paragraph 6 of the writ petition
No,
file.
I want to just find out that
Lordship, I'm coming to that.
when he applied for the post, we want to know what the initial documents he has submitted. With the application, when a date is put, it has to be supported by a document that he has submitted. Goes over right here. When he submitted his
Lordship.
at the time of his joining. What are the original documents he submitted when he
Lordship, the record is not clear, which
then
it's not clear. But from the
we want to know that when he submitted, what are the original documents he submitted at the time when you fill up the form and he signed it.
Lordship, just a minute, please.
So if this document here is submitted, then it is 66.
Lordship, yes. There is an overwriting, your Lordship. It appears, your Lordship, from the record. June 67, whereas there is a handwriting, 7 has been torn into 6. And going by this document, along with the service book, your Lordship, that is
who has done it? It is an interpolation. It is an interpolation.
If we go with this, your Lordship, that means it's because she filled up the form, your Lordship, in the service book, that is the date of 20.
Lordship, this is the matter of concern, and the document which have as well enclosed of the
26
overwriting, Your Lordship, by the
1966, your Lordship.
This is apparent in the record that there is overwriting, Your Lordship. And Your Lordship, may I draw Your Lordship's attention? There's a recent document.
Now, where is the original of this document?
Lordship, that is the only record we have.
Where is the original of this document?
Your Lordship, the original has, so far as the instruction received from the appellant, she has submitted before the office. But she have retained a photocopy of the document.
That
which
is
I
the
have-
only record, your Lordship.
Illegible, but
Which
you
have
you should have the original with you. You should have the original with you.
Lordship, when
Just to take one order. The headmaster Sangpur, the school,